Welcome to this first part of a series of talks on how Brexit has affected design and trademark protection in the UK and Europe. I am James Prankerd Smith, Designs and Patents Associate here at GJE, with about 7 years of experience in design and patent work in the UK and Europe. In this first part, I will briefly go over the rights associated with designs and then explain how those rights have changed following Brexit. So I'll start with an overview of design IP. Firstly, what is a design? A design IP can cover the shape or appearance of a product or a part of a product that is visible during normal use. Designs which can be protected can range from aesthetic designs, such as patterns printed on clothing, to industrial designs, such as the shape of a spare car part. When a design has been registered, the registration gives the owner a monopoly on the design. The owner can use this monopoly to prevent competitors from using the same or highly similar designs, or the owner can license the right to use the design to a third party in order to provide an additional income stream. There are limitations on which designs can be protected. For example, the design must be new and must give a different overall impression to the average user from previous designs. Additionally, design IP cannot protect product features which are just there to perform a technical function. In order to obtain a design registration, a design application is filed with the Intellectual Property Office of either the UK or the EU. It typically takes about 2 weeks to complete the registration process, which is quite quick by most IP standards. That speed is because validity over previous designs is not checked at that stage. So you have some formal checks on your design, such as does it follow the guidelines on how clearly you've depicted your design and so on. But there's no kind of check of whether your design would stand up in court against previous designs. The design is more properly validated if you try to enforce the design against a third party, at which stage they will usually challenge the validity and identify earlier designs which may be similar to yours. Assuming that you don't run into any issues with getting your design registered, the registration can be maintained for up to 25 years. Although this is not infinite, it is adequate for many products which get regular design updates. As an alternative to registration, a design right can be created simply by using the design in a product. This may seem easier, but there are many benefits to registration. Firstly, as I've previously mentioned, the design registration process is very quick and typically only takes about 2 weeks. It's also very low cost by comparison to other IP rights. And as an example, registration of a single design in the UK and the EU generally costs less than £1,500. In return for this relatively modest investment, enforcement of design IP becomes substantially simpler and cheaper. This is particularly because a registered design has a much easier time proving that both you own a design right, because that's already in the document that you've registered, and in showing that a competitor has infringed that design right. Normally, the infringement process involves comparing the design that you've registered to a product that a competitor of yours has produced. On the other hand, if you're trying to rely on an unregistered right, then you will have the additional burden of proving that the competitor copied you. This means showing some evidence that they were sort of looking at your design previously and that their design is so similar that it must have been copied. Design registration also makes it possible to protect the design in multiple countries. When you have filed a design registration in one jurisdiction, such as the UK, this can be used as the basis for further registrations in other jurisdictions, such as the EU and US. On the other hand, unregistered protection is usually only valid in the first jurisdiction where you released the product. Okay, following that overview of the principles of design IP protection, we can now delve into how design IP in the UK and the EU has been affected by Brexit. Of course, the first thing to note is that Brexit has already happened. The main legal impact of Brexit took effect on the 1st of January 2021. Under the current post-Brexit system, EU designs which are newly registered do not cover the UK. However, there are equivalent rights available under the UK design registration system. So if you haven't previously filed UK designs, you are able to obtain the same Europe-wide coverage simply by additionally filing the same design at the UK Intellectual Property Office. The key consideration, therefore, is that the UK and EU are now different jurisdictions. So if you have a Europe-wide strategy, you need to include in that strategy a route to cover both the UK and EU. There are several possible options for covering both the UK and EU. The simplest option is to file the same design at the UK and EU intellectual property offices on the same day. But there are more streamlined approaches. For example, you can file an international design designating both the UK and the EU, as well as any other countries you want to cover, all in one initial application. That is then examined by different offices, but it can help cut down costs if you are covering quite a wide geographical range. Another option to cut down initial costs is to just file a design in one country initially, and then use the priority filing system within the next 6 months to file the same application in other countries. A further note to changes caused by Brexit is that there is a new type of UK unregistered design, which has been created to be equivalent to the previous EU unregistered design. Although there already was a UK unregistered design, it gave slightly different rights from the EU registered design. So for sort of general smoothness of the transition, there are now 2 different possible options for UK unregistered designs. There were also a number of transitional measures to preserve continuity of existing rights. The main one of these was that all EU design registrations that were already granted on the 1st of January 2021 have been cloned to create equivalent UK design registrations. These cloned rights function exactly the same as if they had been initially filed as UK rights on the same date as the EU right was filed. So you get exactly the same protection as you would have had if you had always had a policy of filing separately in the UK. Going forward, this means that there are additional renewal fees if you maintain those cloned designs in both the UK and the EU, because they are now separately funded with separate renewal fees. On the other hand, any EU design applications which were pending on the 1st of January 2021 were not cloned. So there was a slightly different approach taken in that scenario. Nevertheless, it is currently possible for you to request an equivalent UK design right if you had an EU design application pending on the 1st of January 2021. The window for that opportunity to copy applications from the EU to the UK is closing, though, and ends on 30th of September 2021. As a result, it may be worthwhile at this particular stage to review any applications that you may have had pending at the beginning of this year, just to make sure that you do actually have coverage in the UK. Turning to unregistered designs, obviously there's no official register of unregistered rights. So there's nothing that can be copied automatically by a government office. However, the approach for unregistered design rights was just that the existing EU unregistered designs will continue to be valid in the UK for their lifetime, which is at most 3 years. So that's a relatively short-lived arrangement. Thank you for listening to this first part on changes to design rights around the Brexit transition. The next part of this talk series will be presented by my colleague Edward Carstairs, and will be about trademarks and how they've been affected by Brexit. If you would like more information about anything discussed in this talk, please contact me by email or on LinkedIn using the displayed contacts. Alternatively, please browse the GG YouTube channel or visit our website for more IP strategy insights.